All right, good evening, everyone. Can someone confirm that I'm being heard? Good evening. All right. Okay, Chioma, your network is a bit bad, but thank you so much. I think that is enough confirmation for me. So thank you so much for joining. Good evening, everyone, and welcome to week 2 of our JIIPCC Mentorship and Internship program on patents drafting for the third and fourth quarter. I welcome everyone, especially to this session. Please, I would like to ask all our mentees if it's possible to drop a notification in their group to kindly remind our mentees and your co-mentees that the session has officially started. So we'll not be wasting any time. We'll be going into the session for today. And just to give an introduction, I will not be reading our mentor's profile because we already did that yesterday. But just to give an introduction, in today's class, we'll be having Mr. Rakesh Sharma. Mr. Rakesh is already here with us already. So thank you so much, sir, for joining. Thank you for being a part of our program. And secondly, we'll be having Miss Amusa Shukurat Modupeola. Thank you so much, Ma. We are happy to also have you in class today. So today we'll be having presentations from our mentors, right? And then unlike our practice where we have mentees presentation, we'll not be taking mentees presentation this week because of a little mix-up that's occurred from my own end. I kindly and I sincerely apologize to everyone in class today. But hopefully next week we'll be taking presentations from the mentees. But in the light of that, we'll just be receiving an extensive detailed presentation from the mentors, and then we'll be taking questions and answers. So just going straight into what we have for today, I would like to give the floor firstly to Mr. Rakesh so that he can just give us a thorough introduction into the topic for today. Like I said, our topic for today is Introduction to Patents Drafting. You're welcome, Mr. Rakesh.
Thanks for this brief introduction. So today we are going to discuss about the patent drafting. So before I should start, I would want my participants to just give me or tell me the understanding about their patent drafting. Like, what do you understand by the patent drafting? You can just give me your answer in 1 to 2 sentences so that I can start accordingly and let you know. What do you understand by patent drafting in all? Anyone can share their thoughts.
Okay, please, from our mentees that are already on the call, please, if you can we just, okay, thank you, Tonya. Please, you can go ahead and
Good evening, everyone. Good evening, Mr. Rakesh. Good evening, Ms. Amusa. I would say patent drafting basically is the drawing up or the putting together of an invention, a production into writing, stating out the title, the field of invention, the claims, the background of invention, and everything, basically stating out the functionality and technicality of an invention, which you're going to present to the patent office.
Absolutely right. Thanks, Tony, for your answer. Anyone, Dennis, or anyone else who would want to add something more? So shall we start?
we don't have anything. I don't have anything for my answer. Please, you can go ahead and start.
Okay, so and can you share my slides that I had already shared with you, the patent PowerPoint presentation, or shall I share my screen and showcase?
So I will kindly appreciate if you are able to share your slides.
Okay.
I am unable to do that from my end right now.
Okay, I'm doing. Actually, I'm not having the rights to share my screen. It is showing you cannot start screen share while other participant is sharing. So you can stop sharing your screen, then only I will be able to share. Okay, thanks. Just let me know once it is up. So are you able to see the training presentation on patent drafting?
Yes, sir.
Okay, so my fellow friend Amosa would be able to highlight multiple points. So I'm just here to give you high level overview about the patent drafting. So patent drafting is a like art, I would say, which essentially need only three skills, which you have like rightly mentioned about the title, background, and summary in the claims. These are all the theoretical aspects as well as the legal requirements from the patent office. But to learn the patent drafting, one must possess or one person must have three skills in hand. The one is the technical expertise related to that particular domain. The second is the legal expertise that is also related to the jurisdiction. Suppose one is able to like or willing to file in US or Europe or Africa or India, that legal expertise is must. And the third one that is most crucial is the anticipation or the ability to foresee the future, because whatever you are filing, you will be able to reap the benefit or get the benefit of it for next 20 years. So whatever the problems you are facing today for your invention and you are solving it by conventional techniques or the inventive techniques, you are able to find it out today. But what additional techniques you will be able to have which will be beneficial in future, you must have to have those in your mind. So that is the art which need to have these three different skills: technical expertise, legal expertise, and the ability to foresee or anticipate the future, and to be able to write all those things that would be happening in the future, and not for next 100 or 200 years, but only next 10 to 20 years. Then your patent drafting would be considered as much more beneficial. But if you are simply writing whatever solutions you are having at hand, and those solutions are significant only for next 6 months or 1 year, then that drafted application which will be getting published in 18 months won't be having that much like the weightage or the fruitful or the return on investment. So from here, for the drafting program, this is the overview actually. Like the patent drafting, it always comes up with the questions part. Like you must have to question everything whenever you are having a discussion with the inventor, or if you are going to file your own invention, you must have to question each and everything so that you can explain each and everything with minute details in the patent application. Drafting is just writing each and everything in detail so that if any person with ordinary skill in the art, if reading it, that person should be able to create a story or should be able to understand it without some having additional expertise or additional help from somebody else. So this is the art which you or any patent drafter can have or can adopt or can acquire with practice. So if somebody is having the ability to ask questions, so he or she must be able to acquire all the necessary information from the inventors. So this is the very basic step you must have to adopt. So that why and what part are essential for addressing the background, like the problem statement, what the exact problem somebody was facing, and why we are filing this particular application, or why there is a necessity for this new solution. So, but how part is much more essential for proving the novel and inventive aspects of your invention, because you will be getting a patent on how you are solving a particular problem. So these three different types of questions are very crucial whenever you are getting an inventor interview, or you need to acquire information from the inventors. So you must be very particular. No need to assume anything, but you should have to frame your questions in such a manner that you should be able to extract very valuable and to the point, or very like essential information from the inventors, rather than assuming yourself and writing it and deviating the actual essence of the invention from its core principles. So right, asking the right questions is the very basic and the first step of patent drafting. If somebody who is able to write a very good patent application, and we cannot say that who is able to ask the very right set of questions, would not be able to draft a very good patent application. So this is the very basic and first step. The second is, once you have the all the required information, then it is your duty to present that all the collected or gathered information from the inventors in a specific format, that is the anatomy of a patent. So in that particular format, there are different sections in a patent application, like the background, summary, detailed descriptions, claims, abstract, and title. So in that different sections, whatever information you have gathered, you must have to understand where you need to put which information, so that your patent drafting will be valuable. For example, uh, you do not need to put your novel or inventive features in the background section or in the preamble section itself to make it more narrow. So these are the things you will acquire or you will learn with practice. But as a general thumb rule, these are the, I would say, the part of a checklist or the part of a learning which one should learn before starting the patent drafting. In from the third step, this is the from the royalty perspective, like the patent claim design, like what types of claims you are writing, so that there should be maximum infringement. Like we, whenever somebody is drafting a patent application, they have an intent in mind that we have to stop others, because by definition of patents or by definition of claims, it is we like the patents is a legal right which enables an inventor to stop others from making, using, importing or selling. So this is fine from the definition perspective, but actually when somebody is drafting, so they want others to fall into that trap. So these are like the landmines, because if somebody is falling into that trap, so you will be able to charge the royalty to release themselves from your trap. So this is the very crucial aspect which very, I would say, the few people try to understand, but everybody try to create a fence or the boundary line around their invention so that nobody should be able to trespass. But actually, this is a building without boundaries, but full of landmines, where if anybody is trying to trespassing and they are putting their feet on any of those landmines, they will be calling the 911 or any emergency helplines for help, and for that help they will have to pay the royalty. Any questions so far from anyone?
No questions so far, sir.
Okay. So this is the power of filing a patent application. To continue with the previous example I have given, the ring pull technology, which is now available in almost all the soda beverages or other cans. So this initially when it was introduced, the company's share has skyrocketed by 233%. So this is the value of getting a patent. And by having not only their product but by having the licensing fee also, somebody can generate even more revenue. So this is, if we are not deciding to get a patent on our invention, then we are losing our chances of getting the revenue. So we are giving somebody else, like our competitors, to get the patent on the technologies you are working on. So you are making your competition even tougher for yourself if you are not patenting on everything you are doing research and development, or anything you are doing.
Can you hear me?
Yes.
Okay, so let me just come in briefly. I can see people are not asking questions, but I'm going to ask questions so you can mention it. The previous slide was talking about the design patent. How about the patents, the utility patents for that mechanism? Could you just talk more about it? No, not this, the other one. The can, yes. So talking about the design was patented in this. Is it a design patent or a utility patent?
Yeah, actually, it was the design which was patented, but it was the ring pull technology actually, which was patented. It was ring pull technology by Ermal Cleon Fraser. It was patented in 1963 and sold to this aluminium Alcoa company, and it has also licensed it to Pittsburgh Iron Brewing Company. So by purchasing this also, their sales has increased by 233%, because in any ways like this is giving a very unique way in opening the soda cans.
So are we saying this particular technology has both design and utility patents? Is that it?
Actually, design as well as the utility patent. So from this patent number, it's a utility patent, which is showing the mechanism of ring pull technology, like how it is sealed and how that seal is broken and while opening the soda can before drinking.
All right, that's fine. Thank you.
Yeah. Anyone who is having any other questions? So there are like a few categories which can be patented or cannot be patented, and from it varies from country to country. So you can, before proceeding for filing a patent application or drafting a patent application, you must check that list of items which are allowed to have patent or which are not allowed. Like everything which is having any process method or product or system or any chemical composition, it is patentable. But business methods or method of playing games or method of treatments or surgery, or these are the some categories which are not being patentable, or which are like applications, if we are filing around these domains, are not allowed to get patents. So for patent drafting, these are the 4 different stages. We simply say the invention disclosure form, which inventor would submit. You must have to check from this information. This is the information either inventor will provide you in the form of a their own detailed paper or research or something, or you can schedule a call and ask very critical or directed questions so that they should provide you the relevant information. In both ways, you will be able to have that initial information related to invention, and based on that, gathering the initial information, it's duty of the patent drafter, where the second skill comes, where I have emphasized on the legal expertise. So by using that legal expertise, whether this is patented in one particular jurisdiction or not, you must have to make a decision, and if it is patentable, you must have to draft by acquiring or by having three skills in mind, that technical expertise, which is able to help the patent drafter in understanding the complete information mentioned in the invention disclosure form. The second is the legal, and the third is the anticipation or the ability to foresee the future, for the to mention all different embodiments which a patent can acquire. For example, if you can say you have made a like a new or inventive key which is able to unlock the any of the physical locks. So this is your invention lies on a key, but that key is a physical key which can change its dimension or the structure depending on the structure of the lock. But it is only talking about the locks which are conventional. But other embodiments you can capture are like if the locks which are using the fingerprinting sensors, or what are the but for additional embodiments the locks could be having the biometric sensors. Maybe it could be face scanning or the retina scanning or the voice scanning. So these could be your additional embodiments. But if you are limiting your invention only to the physical keys, then you are not doing justice with the idea itself you are going to cover up. So these are the things you must keep it in mind if you are drafting a patent application. Otherwise, you are simply covering that particular immediate or short-term solution which inventor only has provided, and you have just summed up or collated all the information which inventor has provided in one single document in that structured manner which patent office require, and we call it a patent application. But it is not more than a scientific literature. And after the drafting, the next stage will be the prosecution, because the examiner will also review it, and if there is a corresponding prior art, examiner will not allow. But if there are significant new or inventive features in your invention, examiner will issue a notice of allowance. So these are the critical stages. Any questions so far?
Yes, sir. Please, I missed the prosecution part for the ABCD of patent drafting.
Okay.
Yes, apologies.
So that prosecution part is nothing but it is a negotiation between the inventor and the examiner. So examiner will also examine your drafted application, only the claims part, that whether what you are trying to claim is new and inventive. If it is new and inventive, means it is not disclosed in any of the previously disclosed prior arts, then examiner will agree with your claims and he will allow your application. But if your claims are not new or not inventive, then examiner will issue the rejections, and you must have to address all those rejections. This is the part of the patent prosecution, which is a like round of negotiation between the examiner and the applicant in order to get the application allowed.
Okay,
Great.
sir. Thank you, sir.
Okay, great. Any other questions from anyone?
Sir, I won't mind if you can show us an invention disclosure form, so we'll get to see how it is.
Actually, I would be able to share it with you after this meeting, but invention disclosure forms are like you can get it from the WIPO website. If you can simply Google search, you can write invention disclosure form and then type WIPO, then you will be able to get a very detailed invention disclosure form around 10 to 15 pages long, which includes all the essential questions addressed or provided by the WIPO itself. This is the one basic example anyone can check without any hassle. But companies or the clients or inventors have their own specific questions which are confidential information for their own. So they prepare based on their own experience or the client type or the jurisdiction they are handling. So specific answers to those questions are crucial for them. So those kind of invention disclosure forms are, I would say, are the secret sources for those clients or those companies.
Okay, sir. Thank you, sir. Noted.
Yeah, I will be able to share that freely available invention disclosure forms with you, but there is no universal template for invention disclosure form. You can modify it based on your own requirement, based on client's requirement, based on the jurisdiction you are handling. Like it is customizable based on your own preferences. It is not like we are following any thumb rule that it must include this specific information or not that information. It is totally customizable based on the requirements of the patent drafter, like what kind of information a patent drafter is seeking for. Accordingly, he or she can customize the invention disclosure form according to their own preferences.
Okay,
Clear?
sir. Yes, sir. Very clear.
And in that also, you must have to specify all the like purpose of asking the, like here in this slide I have mentioned about asking concrete questions to the inventors. So there are like abstract questions and the concrete. Abstract or concrete means the open-ended and the directed closed-ended questions. So both are important, but at this stage you must have to have asked the directed questions so that you can get very critical information at the very first attempt, and you can make design around or modifications which are acceptable to the inventor around those particular essential information. So this is variations you can propose to the inventor, but critical information you should always get from the inventor.
Yes, sir.
From this example, like we can showcase in left side, this is figure 1 of your invention, which is having two tea pouring, like it is a tea vessel with two pouring spouts, two holes, we can say that. But in the prior art, examiner has cited these three different prior arts. One is the conventional vessel, and the second is the horticulture fertilizer distributor, which is having two spouts for distributing the fertilizers equally from these nozzles. And the third one is having the coffee maker machine with two spouts. But based on the drafter's skill, if they have mentioned the critical aspects of these two nozzles of the figure 1 mentioned on the left side for a pouring vessel, we can differentiate our invention from these three prior arts. Because very basic example, if I must have to highlight for inventive step, that this pouring vessel or the tea kettle will enable a user to fill two cups simultaneously. Clear? So this is the inventive concept from this figure. But if you can see this document from prior art D1, it enables only one particular user to fill one cup at a time. Document D2 is related to fertilizers or the agricultural instrument. It is having nothing to do with the tea pouring or this particular domain. So we can say that this is non-analogous or not related to the field of tea or coffee vending. The third one, it is looking similar, but the purpose and objective is entirely different, because here there are two spouts or two nozzles available, but the rate of flow of coffee or rate of filling of the cups is getting reduced by half. But our objective was to fill the two cups simultaneously like the time it was taking the conventional kettle to fill 1 cup at a time, we are filling 2 cups in the same time. So this was the inventive concept, but none of these three prior arts were able to meet that particular objective. So in that way we can say that our invention is inventive and examiner must have to provide a notice of allowance only when you are writing everything in detail in the patent application. Unless otherwise, examiner can combine all these three prior arts and reject your application, and you cannot do anything at a later stage, which we call the prosecution stage. Any questions so far?
None from me.
Okay, so this is one last suggestion for patent drafting. As we were talking about the very concrete questions to be asked to the inventors, but to flip side, whenever you are writing the claims or you are writing the patent application, you must have to use very broad or the abstract jargon so that your coverage or the scope would be more. For example, like here we have given the example, like rather than writing a toy ball, we should write it like a spherical object so that it should cover multiple other perspectives also. Rather than writing this one as a spring, we should write it energy storing means. So in different from spring, if somebody is mentioning some other damping element also or some other thing except from spring, but which is meeting the same objective, so that should also be covered. Rather than writing like screw, nail or rivets, we are writing fastening means, so it could cover much broader aspects rather than only these three. So whenever you are writing, your scope should be broad, but whenever you are asking the questions to the inventor, it should be directed to very narrow features so that you should not miss all those essential narrow features whenever you are drafting the patent application, and you can explain the best mode of that application in a very clear manner without having any abstraction. Any questions so far?
No, sir.
Okay, so this is only the assignment based on what we have discussed. I will share it with you. Like by looking at this figure, you should be able to understand the invention, or if you need it, you should be able to draft the list of questions to be asked to inventor, what, why, and how. And if you are able to understand it very clearly, you should be able to write down a very narrow independent claim to be discussed with the inventor. So this is the part of the uh, assignment which I will be giving it to you. So that's all from my side. And I would request Amosa to throw some more light on the patent drafting aspects.
All right, thank you so much, Mr. Rakesh. We sincerely do appreciate. Please, we would like to give the floor to Ms. Amusa to also give us a presentation on the topic for today.
Hello, Dennis. Hello, everyone. I think I already presented last week. So I'm just going to, let's just chat and answer some questions. I really do not have much to say today, but like we know, Rakesh has taken us through the process. So because sometimes people don't understand the different aspect of intellectual property. In fact, just last week, a friend messaged me and she was like, I want to file a patent application. And one thing I know is whenever I hear people say, I want to file a patent application, I already know what they want is not patent. It's either a trademark, a copyright, or something else. But because they can't identify which is which, they just tell you, I want to file a patent application. Then when you now start asking questions, that's when you realize that, oh, what you have is actually not something that falls under the patent regime. It's probably something that falls under copyright or trademark or this or that. And this is where it's good to ask questions. This is where the aspect where Mr. Rakesh was talking about comes handy, right? You have to look at the technical expertise, because if you don't have the technical expertise, you probably, or someone will probably have paid you money to file a patent application. And at the end of the day, when you check, you'll be like, so this is not patent. They tell the person, oh, what you are doing is not something that's to do with patent. So like I always do, the first thing first is there has to be a meeting, whether you like it or not. If you don't want to have a meeting, then I'm not going to work on your work, whatever, because you won't come and dump the work on me and expect me to give you magic when you don't even have something that has that element of patent. So you have to know what exactly it is, because the patentability of your invention depends largely on its novelty, its inventiveness, and its industrial applicability. And how can you know this? You have to know this by asking the question of, why do you want to file this patent? Like, what exactly is the reason why you want to file this patent? Then how and what? What is different about what you are doing? Or what's different about what you are doing that is not in the market? Because you want to highlight what's been in the market before, the gap, and what you are trying to solve. If you're not able to highlight a particular solution, then you probably might not be ready for patent. Maybe you want to stay with trade secrets or something else, but not patent, because with patent, you have to be able to identify a particular problem you are trying to solve, or you're probably providing a new way of doing something. There has to be something you are trying to do. So if you look at the examples Rakesh shared earlier, you realize that the kettle with two sprouts is trying to do something, right? Even though it might seem like it's an invention that doesn't make sense, but it does make sense, really, if you look at it. So all of these things have to put into perspective. You want to know why you are doing this, and just like we did last week, we talked about patent search and all. You want to have a good knowledge about what exactly it is you are doing before you decide to go into filing a patent application. Because what if patent application is not exactly what you need? What if what you need is probably a utility model and not a patent application like a patent application? So I think we should just give room for question and answer. So if you have questions, we can probably delve into other aspect that hasn't been mentioned. Thank you. Over to you, Dennis.
Yes, sorry for the delay. Thank you, Ms. Amosa, for just running us through what you felt like we need to know. All right, so please, we want to give room for a little question and answer session. Right. Like I made mention, we will not be having mentees presentation. This class should be more interactive in that sense. So please, if you have any questions that you would like to ask, our two mentors are on ground. So please, you can just kindly ask your questions, and I'm sure they will do well to help you with the answer. So please, does anyone have any questions as regards today's topic, introduction to patent drafting, or just generally any question you may have on patent drafting?
Just a quick one. Let me add in something. I believe Rakesh is still on the call, and this is a very good opportunity for you to understand the diversity of patents and how it works with respect to territoriality and how the laws of different jurisdiction works. So if you want to ask question, you can probably ask question around. So if we are going to talk about it, Rakesh will talk about it from the side of the Indian law. Then I might talk about it from the aspect of Nigerian law. So you're able to see how diverse these laws are. But I think in most or in some instances, somehow, the Nigerian law and Indian law are kind of similar, if I'm not mistaken, because I feel like most of what they can't patent over there, we can't patent over here as well. So you want to ask questions in that light as well, just to put that in. So over to you.
All right, thank you so much, Ma. Esther, I can see Esther is raising her hand. Please, you can go ahead and ask your question.
Okay. Good evening, Ma. Good evening, sir. Thank you so much for so far. I don't know if you can hear me.
Yes, we can.
We can hear you.
Okay. Yes. My question is not necessarily directed at patent, but at what happened last week with the demure trademark.
Okay.
So where I have a little bit of doubt is in the we when we go to file trademark. Now, is there no place where, because I'm actually a beginner, I don't really know so much about it, where you the should I say the person granting the trademark tries to ascertain whether or not the individual in question is actually the originator of that word? Because from what we knew, it was a different content creator that originated the word, and it was someone else who trademarked the word. So is there no place where is there no law governing that aspect? So that
Okay.
the true owner, yes, so that the true owner can really get the trademark for what she invented, the word rather she invented.
Okay, so what I'll say is there's something we all need to know, that filing a trademark application is different from getting your trademark registered. So at the instance of filing, what you just did is just to file and submit your application. It hasn't been granted. So going by this example now, the guy has just filed. The USPTO has not granted him any rights to the work, because according to the USPTO, and I don't know if you've seen my recent post, USPTO operates the first to use system as opposed to the first to file system, which we operate in Nigeria. I'm not sure what is operated in India, but Nigeria operate the first to file system, whereby the person that filed first is given that upper hand. And seriously, we have so many backups, backlogs and things to do than checking the genuinity of who is filing. It is left to the owner of the trademark to take that up. So if somebody should come to the trademark registry to file a trademark application, I don't have to go and start looking for who is filing. Is it Ashake? Okay, let's say, what was one of those Ashake slogan? Okay, I remember there was a time a client wanted to file a trademark for Palazzo, right? And yes, Ashake sang and there was Palazzo in his music. Then one of the trademark examiner in Nigeria told the client, or told the person that was the agent, that you can't file for Palazzo because Ashake has Palazzo in his music. And I was like, why do you want to gatekeep for Ashake? Did he send you message? In fact, this person is trying to file under the class for restaurants and hospitality. If Ashake is not filing, then that's his problem. So once the person files and the trademark owner now sees that, oh, and that is where publication comes in. So when you file the trademark application, it goes through, the first thing you're supposed to do initially is to do a search. But if you don't do a search, you can file directly. Once you file, you get acknowledgement. Acknowledgement is just saying, oh, we've seen that you want to file an application. After acknowledgement, they carry out examination to check if your trademark can be accepted based on the absolute and what's it called, that one? 2 grounds, sure. So they have to check, is it okay? Is it distinctive? Is it not violates public morality? Is it similar to somebody's mark? So once they do other examination, absolute and relative ground, yes. If you are okay with they do that examination and you're not violating any objection or that, then it goes on and they give you your acceptance letter. Still, acceptance letter is not saying you have a trademark registered. Acceptance letter is just saying, okay, fine. To some extent, we've accepted your application. After that, this your mark will be published in the trademark journal. Now, once it is published, there will be like a time frame of like 60 days, which is like 3 months, to say, oh, everyone, look, this person wants to file a trademark application and we've filed, and this is the mark here. If you think this mark is similar to your mark or you think it should not be granted, come out and speak. At that moment, and this is another reason why we tell you that your IP should not end at protection. You need to police. A brand owner that is policing and following up with the publication will probably come across that name being published. And once you see that it has been published, you can raise opposition to oppose it at that point. So this is why I said that the application process doesn't grant you automatic right. You just applied. So unlike the US, like I said, that they operate the first to use system, what the guy initially filed is probably an intent to use. You need to show proof that, yes, I'm actually using this mark in commerce before you can proceed to the stage whereby your application will now be accepted. So if you go to the USPTO website and you try to check very demure, very mindful, you'll see that the application is still pending. It hasn't been accepted yet. It just filed. So that filing doesn't give him the automatic ownership for that name. I don't know if that answers your question.
Yes, it does. Thank you very much, ma.
Okay, you're welcome.
All right, thank you so much, Esther. So please, can we have more questions from our mentees that are on the call? Some people reached out and said they were having network issues, but irrespective, those that are on the call that were able to listen to Mr. Rakesh's presentation and just generally have questions, you can ask your question. You can send your questions into the chat box, and we'll read it out to the mentor. So, do we have more people with questions?
Miss
Please
Amosa, sorry, when you were explaining the trademark stages, I missed something. You said absolute, and after the acknowledgement, there's a stage before the acceptance letter.
No, I was saying that it has to be examined. So it's going to examine as to the absolute and relative ground. So the absolute ground is where you have the ground whereby it's distinctive, is not similar to somebody's mark, and so on and so forth. Then the relative mark comes in under maybe you have flag, you have this and that. Things that are not meant to be trademark, you have them under your as your trademark. So you can read up on that as well.
Okay, ma. Thank you, ma.
So do we have any other question?
So
Mr.
please, if you
Rakesh
have a
is here all the
question,
way from India. If you guys should have question, please.
yes, please, can we have questions, please?
How about the document you spoke about, Dennis? Has it been published or has it been submitted?
Sorry, I didn't get you, ma.
I said the article. You said the
Yes, we gave them an assignment for them to submit articles. We've not yet published it yet. We are still getting articles. So once, I think within week 5, then we'll start publishing the articles that have been submitted already.
Participants were supposed to write an article. Has that been done?
No, not yet, ma. Some of them have written the articles and submitted. But for the publications, we'll be starting publications from week 5 up till after the program, and just keep updating the articles on our LinkedIn page.
Okay.
Yes, thank you very much, ma. So please, do we have any more questions from mentees?
Yes. So sorry, I want to take us back to last week. Last week, when Ms. Amusa was speaking, she spoke about types of search. Prior art search, basically, it's when you want to submit a patent, application that you feel it's new, but I didn't really get the invalidity search.
Can you please repeat your question?
Okay, sir. I said last week when Ms. Amosa spoke to us, she spoke about the different types of patent search, prior art search, invalidity search, freedom to operate. I understood the prior art is when you do a search for an innovation you believe is new. So you're just carrying out a search to find out if there is a similar art to the one you want to patent. But in terms of invalidity search, I didn't understand it.
So, Amusa, would you like to answer the question or shall I answer?
Mr. Rakesh, please, I would also like to hear from you, sir. Do you have any?
Okay, Rakesh, please, you can go ahead.
Okay, so as in previous section or previous session, sorry, different searches might have like introduced by Amosa. But I would like to just add one more point on to that, that different searches are performed at different stages of the patent life cycle. Suppose before drafting a patent application, patentability is being searched, or if you want to launch your product somewhere, you are performing the freedom to operate search. And invalidity is always performed once after the patent gets granted and somebody is trying to charge royalty from someone. So as a defense mechanism, somebody is trying to prove their patent invalid. So these three are different stages where these three different types of searches are being performed. Patentability is before the drafting or before filing of the patent application, so that your all time, energy, and money related efforts should not get wasted. Whatever examiner is going to perform, you are just trying to make a replica of the same by performing your own patentability search. This is one aspect. The second is, if without any patents, you are just trying to launch your product in one particular jurisdiction, then you must have to check, and for that particular check or clearance, you are performing that freedom to trade search. And invalidity is always a defense mechanism for something. Suppose somebody is suing you for paying the royalty, so for as a defense mechanism, rather than paying royalty, you are trying to uh, prove their patents invalid. So these are the three aspects I can give you a very high. I had just tried to give you a very high level overview about the different searches. Esther, you have any question? You are raising your hand.
I don't know who actually asked the question. I hope that answered your question. My network is kind of breaking. I don't know.
Yes, ma, it does.
Okay.
All right, thank you. Esther, we can see your hand up. Please, you can go ahead and ask your question.
Sorry, Mr. Dennis, I have one more question.
Yes, I said you can go ahead and ask.
Please proceed.
Okay, so I want to ask, if you file a patent and it's not been granted yet, but your client goes ahead to launch, are there any consequences?
In that scenario, if your patent is not granted yet, you cannot do anything. First of all, you can monitor, wait and watch policy you can follow. But if you are very confident and like sure that the features which are in the product of your competitor are the exact features you will be able to get as the granted one, then you can make your strategy prepared for yourself before it's grant. You cannot do anything rather than just submitting a notice to the competitor that this is your product features are infringing on my patent. But it will be having repercussions also, because it will make them aware, and chances would be high that before the grant of your patent they might start manufacturing the product with different features which would be not infringing on your patent. So chances of missing the huge royalty would be minimized.
If I can add to that, Esther, just correct me if I'm right. Are you trying to ask if launching your product in the market after filing a patent application, is it going to invalidate the application? Is that your question?
Ma,
Okay,
not only
that's not me. It's not Esther.
Yes, it's
Okay.
not Esther, it's Soye. Ma,
Okay.
apart from invalidating the filing process, as Mr. Rakesh said, the possibility of, will I say, a competitor now duplicating your invention prior to you getting the priority over it, it's quite
It's
scary.
high. It's high
Yes,
because
it's very
you're
high.
not
Yes.
certain. You're not certain if you actually get a patent granted for it or not.
But also, as you said, does it actually invalidate the application?
With respect to priority, it doesn't invalidate your application. It doesn't invalidate your application because even when you filed, you can still work the invention. It's just that the chances, you're not sure if it will be granted or not, because during examination, you might be asked to tweak one or two things, add this, remove that, do this, do that. But by the time you're already putting this in the market, what you might eventually get patented might be different from what you have in the market.
Okay, ma. Thank you, ma.
You're welcome.
Okay. I actually read a post from you on LinkedIn where you mentioned some of the nuances briefly, but I still wanted to please throw more light on it. And it's the line between trade patent and trade secret. So where do we draw the line between giving details of the patent work to the government in exchange for the protection and then protecting the secret of the business?
Well, it depends on the industry you are in, because if you are in a fast-moving industry, you might not want to use trade secrets, because a fast-moving industry, things always go fast and people are likely to reverse engineer. And when they reverse engineer that your particular trade secret and eventually file a patent for it, then they can give you a cease and desist letter to stop using what you call your own trade secret, because they now have a patent application for it. So it all boils down to the industry you are in and how you actually want to protect yourself. Do you want a protection period that is likely to last eternity? Or do you want a protection period of 20 years and once it's done, it goes to the public domain? Take a look at Coca-Cola. Coca-Cola does not have a patent application. What they've been using all this while is trade secrets. And even though some people come out to say, oh, we have Coca-Cola trade secrets, people just don't listen to them. But if someone has been able to probably reverse engineer Coca-Cola's trade secrets and file a patent for that, then the person is likely to stop Coca-Cola from using that trade secret, because they now have a patent for it. Because that secret would have been disclosed according to the patent application. So do you understand that?
Yes, thank you very much, ma.
Rakesh, you might want to add something to that too.
Yeah, like totally agree with you, Amosa, on this, like how to decide whether to go for patent or trade secret. So there is a very thin line in making a decision, and that decision is always very crucial. Like for fast moving industry and considering the reverse engineering, so these all are different aspects, as well as the business strategy also. Like for example, for maintaining your internal processes, like internal process means you are following some chain of process for manufacturing something, and those processes are very crucial for the overall development of that project. And you, rather than patenting it, because that will only give you the monopoly for the next 20 years, you want to keep it trade secret for maintaining or for ensuring the quality, like the quality check or the final production of something, or for like Amosa has given the example of Coca-Cola. I am more interested in the example of KFC secret recipe.
Yeah.
So these are all the trade secrets which did not fall into the 20 years lifespan in exchange of their own secret sauce, but they are spending huge bucks on maintaining their trade secret. But once it is revealed, they cannot patent it, or they cannot stop anyone by suing or by showing their legal rights. So there is very thin line, but it all depends on the business or the type of clients you are handling, and accordingly you can decide which particular idea or invention you should proceed with patents, and which particular ideas you should keep it trade secret. As a general rule or suggestion, I can tell, for all the internal processes or internal like procedures some company is following, they always tend to keep it a trade secret. But for everything they are manufacturing for either the clients or the customers or general public, everything they are trying to get a patent for it, because anyhow the product is going to be used by the end customers, and as Amosa said, by doing the reverse engineering they would be able to decode everything we have encoded in those products. So like this is a very basic, I can say the high level suggestion I am giving for all the internal and external, but it always depends on the business strategy, which inventions or ideas to keep trade secret, because you or the business might be having the impression that this will last more than 20 years longer, or we are not entitled to share this with any of our competitor. These two are the primary requirements for anything, to keep it a trade secret and not to go for the patents side. But for anything except from these two requirements, which you think if disclosed with anyone, and if anyone is also practicing, won't affect our core business, and if we found someone who is practicing, we can generate money out of it, then patent is the best option for that particular idea.
All right.
That's all.
Thank you so much, Mr. Rakesh. I think we've had a few people ask questions, mostly between Esther and Tonye. So please, I can still see more people on call. I can see Emmanuel, I can see Blessed, right? So please, does any of you have any other question? If not, I think it would be safe for us to call it a night. Okay. All right. So in the absence of any question, for those who have a little lighting in their background, please, I would just kindly like to request that we turn on our videos so that we can take a quick screenshot, and then we can just close for today. For those that have a little light in their background, please, I would like to kindly request that you turn on your video. Thank you so much, Mr. Rakesh. Mr. Rakesh is currently in India, and the time zone is a little bit, it's actually very late where he is. And thank you so much, sir, for sparing your time. Okay, can we have mentees turn on their videos, please, if you can? Thank you so much. Thank you so much, Ms. Amusa. All right, thank you, Tonye. Thank you, Blessed. All right, we are done with that. Thank you so much. We sincerely do appreciate your time and your efforts. Like I said, Mr. Rakesh, I think it's almost midnight where Mr. Rakesh is. So it's a lot of efforts from his end. Thank you so much, sir, for your time. We really, really sincerely do appreciate all that you do for us. And thank you to Mrs. Amosa Shukurat. I will be exaggerating if I will not be exaggerating if I will say she's so committed to this program. I think she's also in the IP group, and she's also here, so it's always nice, and she's always present. So thank you so much, Ma. We really sincerely do appreciate everything that you do for us, and I'm sure our mentees are also very appreciative of everything that you do. So with this, we've come to the end of today's session. Good night, everyone, and take care.
Bye. Bye, Rakesh.
Bye.
Bye. Good night. Thank you.
Bye.
Good night.